Folks, hundreds of years ago, when this whole America thing started, we had this piece of paper, we still do, it's called the Constitution. And then after they wrote that, they amended it a couple times. And the Second Amendment to that document says that we, the people, get to bear arms. Now, there are lots of arguments about who those people are. And that's what we're going to talk about, because there was a recent case out of the Supreme Court, the Bruen case. And the Bruen case said, who are these people that get to bear arms and who doesn't get to bear arms? Because there are some people that don't get to do it. The way that Bruen has shaken up the gun world and the Second Amendment world is that we are now having to look at a restriction to the Second Amendment. If you are going to restrict somebody's gun rights, folks, and you are a government entity, you can do it. But under Bruen, you have to look at the tradition and the history of gun restrictions to determine whether this particular restriction is constitutional or not. And this is just turning the world upside down. So one of the ways it's turning the world upside down is because we have convicted felons with a lifetime ban on their right to bear arms. And if you look at the history of the Second Amendment and bearing arms, you will find that for the most part, they were still allowed to bear arms. Even if you were convicted of a felony, you could still bear arms. Now that is a problem that Bruen is creating. And I'm going to talk about Garland v. Range today, because what happened in Garland v. Range is Brian Range was convicted in 1995 of food stamp fraud. And the fraud was he reported his income a couple $1,000, like $2,000 lower than it should be, maybe to get the food stamps, right? And he pled to that felony. He admitted to that felony, even though he said, I guess his wife filled out the forms, but he admitted to it and got 3 years of probation. Now, fast forward, this is 1995 that he's convicted of a felony, and he has a lifetime ban as a result of that reporting his income $2,000 lower. He cannot own a firearm for the rest of his life. And he files an appeal and says, I want a gun. I want to hunt. I want it for protection. And the court said, no, piss off. You're a convicted felon. We're not going to allow you to have a gun. And he files an appeal. And the United States Third District Court of Appeals looked at it in light of that recent case Bruen, which I told you about and I have another video about. They said, you know what? This guy is a nonviolent felony offender. He has no criminal history whatsoever other than food stamp fraud in 1995. And we can find nothing, per Bruen, no history, no tradition that would ban a guy like Brian Range from having a gun. We, the people, get to bear arms. And it looks like those people include Brian Range. So the Third District Court of Appeal said, Brian, you can own a gun. Even though you're a convicted felon, you get to own a gun. Well, the government went ballistic, as you might expect, and they appealed it up to the United States Supreme Court. Now, in July of 2024, just recently, depending on when you're watching this, the United States Supreme Court told Brian Range that we're remanding your case to further review it in light of a recent case, Rahimi. All right, so now we've got another case, Rahimi, which I've done another video about. But here's what happened to Rahimi. Rahimi is not a convicted felon. He has never been accused of a crime, arrested, convicted of a crime, but he has a lifetime ban on the possession of a firearm because at some point in a relationship situation, an ex went to a judge and wanted a domestic violence injunction against Rahimi. Again, this is not criminal. This is just a stay away order with an accusation of, well, maybe there's domestic violence, so I want to keep him away. This guy has no criminal record, nothing that's provable in a criminal court, no arrest, no convictions, but the man cannot own a firearm ever because some judge granted an injunction in a case a long time ago. Rahimi went to the Supreme Court in light of Bruen and said, we don't think there's any historical data that would keep somebody like me. I've never been convicted of a crime. I just have this injunction. It's a civil injunction. Why are you preventing me from exercising my Second Amendment right? And the Supreme Court in Rahimi said, yeah, we are going to restrict you. There is a history and there is a tradition of folks that have violent tendencies, and a domestic violence injunction might not be a criminal act, but it might be a violent tendency of some sort. There's a history for it. There's a tradition of restricting gun rights under those circumstances, and we are going to uphold your gun suspension. Rahimi, you cannot own a gun. So that is where Garland versus Range is that they have to now take a look at Rahimi and say, Range, do you fit into this little narrow lane? Which I don't think he does. Range is actually going to get his gun rights back on further review in the 3rd District Court of Appeal. That's where we are. I'm telling you folks, this Second Amendment stuff is moving fast and it's interesting, and I'll keep you posted as things develop.